And we are now resuming on those discussions. What I will allow the ministry to speak generally, and thereafter we'll hear from Solgen and CPC.
Thank you, Minister. Earlier, the discussion, I believe that the ministry may have misconstrued the questions that was being asked. And the answer really was in relation to the firefighter and police. We had not realized that it had taken a broader context. The policy of the ministry is that the OSH legislation will be applicable to all workplaces. So it will be applicable to the PCBUs, workers, and the workplaces generally. In November 18, 2019, we had communicated when we were looking at the issue of branch of economic activities, we had communicated our intent to resign from that position, and because when we looked at the scheme of the act, what we were proposing was inconsistent. So we had put forward the intent that we will be applying to all workplaces. In June, when we were dealing with the issue of the function of the authority, we had outlined the functions that we had indicated. The bill contained functions as it relates to the director, and with the policy shift as it relates to the body corporate, we had indicated the function that would be applicable to the body corporate itself. And one of the functions that we had said was that, and this would have been in the policy document, Ministry of Labor and Social Security Policy for the Establishment of Occupational Safety and Health Authority, revised June 5. I think we presented it on the 8th. And we indicated that one of the functions would be to collaborate with other entities or bodies which have responsibility for safety and health. So that's the intent of the ministry, that it would apply to all workplaces.
All right.
That's the answer to the question of precedence.
I think that's a general comment was made. It has not been specific to some of the issues that were raised. I know the issue of precedence as put forward by you, Member Brown, and supported by Solgen. But one thing was clear, is that it's not a simple matter that can be resolved here. Clearly the ministry had not sufficiently addressed its mind to that kind of position. And Solgen has indicated that some amount of consultation has to be involved. If it is that the OSH is going to supersede other legislations which may have provisions relating to workplace, to safety and health. So I believe that as a ministry we have to look at the policy as it now stands and bear in mind the recommendation and the advice from the Solgen. I believe that should guide us in terms of how we will proceed.
You're saying that's how we should read Mrs. Michael's response? Or
Certainly that has to be incorporated, yes. Yes.
So the policy is that it would apply to all workplaces?
All workplaces, yes. Okay. Yes.
In response to the question from the Parliamentary Council rep, it will apply to all workplaces, but the issue of the precedent is there to come back to us. I just want to be clear for
yes,
the record.
Member Brown. Exactly that. Of what? Oh, in terms of precedence. So he went a little further than what you have indicated, that the bill applies to all workplaces. The matter of precedence is something that the ministry has to revert to the committee on. So we will defer that part until a later date, and we will move to clause 177, ministry.
For clause 177, we are putting forth that subclause 4D should be deleted. The AGC has also put forward a recommendation for clause 177.2C to be deleted, which we are in agreement with.
Mr. Mahan, perhaps you could give some reason as to why you're proposing 4D to be deleted before you move on to the comments by AGC.
Given the nature of what C says, which states the provision of the act that the officer believes is being or is like to be contravened by that activity. Based on what we had outlined, the intent of the non-disturbance notices, then this would not have been applicable because it is in relation to doing an investigation for establishing the root cause of an accident, or if there is a suspected issue that requires that level of investigation. So it is not confirmed that there is a contravention, it's really to investigate.
Very well. You could now proceed to...
Before you get
Yes.
there, Chair, am I to take it that the things you're deleting are contained elsewhere in the bill, especially 39 or thereabout? The why you shouldn't disturb? Are they contained elsewhere in the bill? Your 4, for example, your 177.4.
What I'm saying is that for the non-disturbance notice, what is set out in C, the other notices would have pretty much covered, because those are seeking to address situations where the provision of the act is being or is like to be contravened, which we had already discussed in the earlier part of this morning. So it is there already under the other notices, and the purpose of this notice is not such.
For the, Mr. Mohan, that you're asking to be deleted, it relates to, that is associated with a police investigation?
Yes, this was in light of the comments I made earlier in relation to the policy.
Okay.
That is not to limit the
Very
police.
well, okay. Clear.
So based on the discussion this morning, not sure if, from a drafting perspective, if
Yes,
we will
it
be
will
including it, or as Ms. Seeley-Brown has pointed out, for it to be probably moved under incident investigation.
You mean
Yes,
to move
Mrs.
this?
Seeley-Brown.
What's the question you're asking, Mr. Mohan?
No, I was asking if, for the purposes of the discussion this morning, would we want to move this to the incident investigation section of the bill?
Yes, yes, in part 3, yes, agreed.
Okay.
Yes, Aldrin.
I have a question in relation to 4C, that the notice would not prevent any action that is essential to make the site safe or to prevent a further incident. Is there some oversight on that? Because this could be abused. An employer could say they take action to make a site safe when it's really to cover something up. Is there some sort of oversight? I'm not sure how it would operate. Meaning the authority, is it that the authority? I'm trying to think it through, because I guess the thing is you do need to leave the employer some amount of leeway to ensure that if there really is some major danger that they take some steps, but I could also see some potential abuse. And I don't know if there is any happy medium. I'm not sure.
I raised the question this morning, and Senator Brown had somehow sought to suggest me saying about cover up. And here it comes again, but it sounds better. No. But the question, the issue, is that you are quite correct in that you may have a situation where there was an accident or an incident that never caused any damage or any harm, but it requires an investigation in order to prevent it from happening in the future. And in this case, you really want that state of disturbance to ensure that, one, a proper investigation takes place, maybe by an independent party, and in this case, the authority. And two, there's always the question of any cover-up, because we can't rule that out. And that's why I am of the view that this particular reference is important, to ensure that an investigation takes place, because you have some entities that I have known in the past that really don't want an investigation take place because they may fear future liability.
Yes, Sandra.
I really thought I was here all morning, but somehow it missed me when it came up earlier this morning. I'm looking, though, back at same 4C and how it would relate to 2B. Because 2B is saying in the notice, you're going to set out the measures that must be taken to preserve it, to prevent disturbance. So couldn't you then, because measures to prevent disturbance could also include things to say, make it safe, meaning that at least that would be the oversight, in a way, that the notice should deal with those things. I mean, you could expand it if you want to expand 2B, right, to just include that. So at least then it is clear that the authority has looked at it and is now saying, well, these are certain measures you can take, but it would not interfere with our investigation.
Mr. Mahan spoke this morning about making recommendations. That's the recommendations that you'll be making in order to preserve, but to put measures in place to also protect. Cordon off, line off, put retaining wall, whatever.
And so, Chairman,
Yes, member.
while I eschew the cover-up part, because there are some unscrupulous employers who will do that, I want to believe that the majority are good faith employers. But would consultation with the USH officer or the authority help us in this? Because if some action needs to be taken, as Senator Gill said, you may need to cordon, you may need to do something which in a way could disturb, but it may be a minor disturbance. But if they consult with the USH officer and there's a sign off on it, then there's no harm done if the good faith action is being taken. And so maybe that's what we could put there.
Yes, Mr. Mohan. See, you may want to take us to what is the intent of 4C so that we are clearer.
And perhaps he can also explain 39, because this is, yes, if you look at clause 39, yes, not a full repeat. So there are some overlaps. There are some things in 177. There are two things that are one thing. Oh no. Okay, yes, I repeat, yes.
Very well. All right, Ministry, proceed. Yes, you have heard the comments.
So, yes, we have heard the comments, and we take what the Sergeant has also mentioned about probably exploring 77.2b, how we can incorporate, and what CPC has said about moving it around to the section that speaks to the incident notification. What we can do is ensure that the language is consistent as well.
Yes.
Did we indicate at some point in time that this was one of the legislations that we're going to have a code of practice?
Yes.
And so particular guidelines of this nature could be established in the code of practice as to how to treat with non-disturbance and things like that. That is the same consultation that Member Brown would be speaking about.
Yes.
Where the recommendations can be given and our guidance.
Yes. The discussion on code of practice has been raised, Member Brown. I believe there's a provision in the bill also that deals with that. Yes. Sorry. Sergeant, yes.
Mr. Basco brought to my attention the OSH bill of Trinidad and Tobago, and perhaps the ministry would also want to take a closer look at their section 47. Preservation of scene is a marginal note, where a person, so they don't give as much discretion at all. Where a person is killed or sustains a critical injury at an industrial establishment, no person shall, except for the purpose of 1, saving life or relieving human suffering, b, maintaining an essential public utility service or public transportation system, or c, preventing unnecessary damage to equipment or other property, interfere with, disturb, destroy. So they can't do anything else. It's not as wide as what we have. It's much more limited in terms of, say, what a PCBU then could do to a site. That's another way.
The only concern I have with that is the term industrial establishment.
Yes, it's different. No, yeah. So we wouldn't have used it, but it's just to give an idea of. But right, their remit is different than ours. But it's just that in terms of where we have indicated that they could take other action, which could be a little wider and it's a little vaguer. Granted, it gives some more discretion. This is very narrow in the remit about what action can be done when you need to preserve a site.
Could we get a sense, Chair?
Yes.
Of how Trinidad deal with the police investigation? I don't know if you have that, Mr. Basco.
Well, we will revert to that as soon as the information is available. Ministry, I've heard the recommendation that has been put forward.
Yes, we have, yes. And we have noted the suggestion about Section 47 of the Trinidad Act.
Yes.
So we will look at it.
So maybe now proceed to 178.
No, Chair.
Yes.
Under 178.3. We put the burden on the PCBU, and this is not the usual course. Could I hear why we put in the burden of proof? 178.3. Huh? It come out? Oh, sorry. It's deleted.
Ministry?
That's deleted, you say?
Yes. Yes, but...
yes, somewhere else,
on the document,
but not here, so.
Document submitted, there's no reference to it. 178.3, in terms of evidential burden and where it lies, Let me hear you on that. You have heard Solgen, CPC,
Yes.
concerns raised by Member Brown.
Right. So that should be deleted.
Okay. Yes, Mr. Mahan, if we go back to the document from AGC 175, clause 175, it speaks to the marginal notes. If we could just take that so it is minuted in our records here.
Yes, we have no objection to what was suggested by AGC for the marginal note.
Okay. Yes. CPC. Yes, could you use your mic, yes?
Chair, we're going to come back to these provisions. All these provisions that deal with prohibition notices and so, right? We're coming back to them. That wasn't the agreement.
Okay, fine.
That's why I never raised it. It
Fine,
can't be written like that.
So the adjustments may include the marginal notes. Yes.
Because the direction may be part of the
Okay.
notice.
Very well. So
Yeah,
we will
something.
revert to that at a later date. So let's proceed to 179.
One question, Chair.
Oh, Mr. Simmons, then Skeffrey. Good.
Yeah, I just wanted to clarify why it is for the prohibition notice, I noticed for paragraph A, they seem to have expanded the places for which a prohibition notice could be issued. I'm just
What
wondering.
are you, yes,
If you look on there,
reading from?
which page is this?
From the
Look
ministry
on the
document?
Ministry document,
Oh, page 2?
page 2. It's cut off on mine.
Okay.
And
Under
at-
173?
At 1A, I'm just wondering why the workplace, part of a workplace plan, substance or structure. I'm wondering why that was done.
Why it has been worded like this?
Correct. Why wasn't workplace just sufficient?
Okay. Is it that you're saying that the definition of workplace is broad enough to cover everything that is in A here? Okay. Ministry, I do not know if we have already established a definition for workplace, but you can comment on it.
Well, what we wanted to ensure that we're not just looking at activity, but also the conditions. Because you may have a situation where you have a plant or a substance. It could be, use an example from this morning, something radioactive.
Yes,
So-
Mr. Mahan, sorry to cut you. I think what legal reform is asking, whether or not we need to set out 173, 1A in the way we have done instead of just using the word workplace. So it could have been condition at the workplace or activity at the workplace. I think that is what they are asking.
Well, we had actually represented it in our document as A and B.
Yes. Okay, let me hear you, Mrs. Seeley Brown. I think Mr. Simmons just asked.
We agreed that we needed to fix it, Mr. Simmons.
So the drafters will deal with it.
Yeah, because it doesn't read well the way it's drafted here. It's written here.
Mhm.
So if it may be that you want to separate workplace or part of workplace and deal with that.
I'm actually querying the need for those words since they're already a part of the workplace.
Workplace, or you can start by saying a condition such as what. Yeah, it can be redrafted. I have to just look at it and see how we.
All right, so the drafters will deal with that. So we'll proceed.
Mr.
Yes,
Chair,
Mr. Scott.
I just focus on 178. I know that we'll come back to the whole issue of the various notices. But the objective here is to have compliance with your non-disturbance notice. And you have, back in the 177, while we're going to review it, you have a number of exceptions, right? Then we see we have reasonable excuse again. And to me, this is a broad general term. So I don't know, you have listed a number of things that could prevent you from adhering to the notice. But when a person, again, without reasonable excuse, can refuse to comply. So I am not clear what else could it be, and then who will measure whether that excuse is reasonable or not, after you have listed a number that you have exemption for.
I'll allow Mrs. Seeley Brown to respond. Yes.
I agree with the member, Chair, because you have already listed what would be required. When you put this whole defense of reasonable excuse, it creates a difficulty for the prosecution. It's a bar that they have to basically jump over in order to even prosecute for the offense. It should just be, if you don't comply with the notice, and it should be the same steps that we agree that we would take with the other notices, where you have that whole thing about you issue a warning, what Mrs. Aldred was speaking to in relation to the Casino Gaming Act. That same sort of procedure should be used before you get to the criminal liability, that warning and, yeah.
So we will allow CPC to address that? Mrs. Seeley Brown? Yes.
When they look at the provisions,
Okay,
they agree that that is the way.
All right, Minister.
So we'll be guided by what CP has said, and we had already noted the recommendations in terms of the hierarchy approach.
Okay, very well. So we move to 179.
179. The reference to hush officer should be changed to authority. The reference to clause 176 should be also changed to 177.
He or she goes. Once you put the authority there, he or she goes.
Yes, and the drafters would make the necessary adjustment.
So we agree, members. Very well. Proceed, Mr. Mohan.
For the section general requirements applying to notices, clause 181, the notice should be in a prescribed form. 181 says that the notice shall be in writing, so we want to change that to say it should be in a prescribed form.
Yes, do we agree? Proceed. Yes.
This is where maybe the suggestion was made earlier that all the notices should be listed and defined.
Yes, Mrs. Seeley Brown.
Waiting until he was finished with the part to suggest, Chair, that the general requirements should come up front. So you list what the notices are, and in the general requirements you could put in even the issues that we speak about with how if you contravene all the steps, and then you deal with the actual notices. Yes, yeah. So we will just shift it around and.
Very well. So it is to be reformatted.
Yes.
Good. Proceed, Mr. Mohan.
Clause 184, subclause.
Oh. Yes, yes. So, yes, 182 members. Any comments or concerns?
That you want to say an improvement notice or a prohibition notice may refer to a code of practice, because I don't understand the insertion of the word of direction. Is it not just that the notice may contain or may refer to a code of practice, rather than introduce this new term direction without more?
So I understand that if you get the improvement notice and you want to know how it's applied, you can look into the code of practice as a guideline. Is that what you're saying? No? No, I'm asking if that's what you are saying.
The notice will direct you as to how you should respond to a contravention or an activity that has occurred. So why I'm not understanding the use of the word direction here? Yes. It says yes, so just say a notice may refer to.
And Chair, it is important, I mentioned earlier, it's important to clarify direction and recommendation in this 181 to 183, because if you go to at 182, it speaks to direction, including a improvement notice or prohibition notice, which we are now told are going to be prescribed. So there's a special form. Now, with that form says direction, and then later on it says recommendation. Is there an interchange between direction and recommendation? And I raise that because at 183.2 it says it's not an offense to fail to comply with recommendations in a notice. So all of that has to be clear up.
Yes.
Sorry.
Yes, no, Member Gill, I'll take you before CPC. Oh, you're yielding. I understand.
No, but I really don't see the importance of clause 183. Yes.
Or 183.
No. No, but why do we even need to say that it may include recommendations, especially if you don't have to comply with them?
Okay.
It says an improvement notice may include recommendations. It's not an offense to fail to comply with recommendations in a notice. So what's the point?
Okay.
Yeah, I
Mr.
think we should
Simmons,
delete.
you
I think
have
183 should be deleted, Chair.
Mr. Simmons, you have any comment?
I thought
183.
she had actually said, I believe she had said 182, not 183. So I was wondering what she was referring to.
No, I didn't hear that,
Mr.
Mr.
Simmons, that's near Mr. Simmons, Chair.
Could you repeat? Yeah.
I believe she was referring to 182, but she said she's actually referring to 183.
Okay, so do you agree with the suggestion that 183 be deleted?
I really and truly don't have, but if you look at it this way, if it includes recommendations, I'm not sure if the form is going to specify distinction between directions and recommendations. If it doesn't, then you won't know the difference between the two and you just have to comply with it. So it depends on how the ministry wants to fix it.
Yes, very well.
But as it is, it would have to specify a distinction between directions and recommendations if it's included.
Okay, very well. Member Gill?
No, remember, and I'm speaking to 182, where I referenced earlier the code of practice, and so here it is, giving some sort of a guideline. But then when I look at 183, and using the word may include recommendations, so some will and some won't. So why you need it? And you're using a prescribed form.
Yes. All right, Ministry. Yes,
Yes, the intent was to have it separated on the form, the prescribed form, having a section that deals with the direction, which is mandatory. The direction has to be complied with. And the recommendation would be a separate area on that form. So in relation to the code of practice, the code of practice would have been an established standard that has been accepted that this is the approach that must be taken to remedy a particular situation. But in situations where you may not have a standard or a code of practice, there may be, based on experience, a recommendation that could be made as to how to approach the remedial work. So it is just really to give that flexibility where the authority can make some recommendations as to what can be done. Because it's not a code of practice, because it's not in a regulation, because those are really the minimum standards that we are setting with the Act and regulations, that they can still meet that.
So in terms of retaining it in the bill? Yes. Is there a comment from the ministry?
But why you want it in the bill? I mean, if you make a recommendation, it can be administrative purpose. So you're giving notice, and the person conducting the business might ask through a dialogue. But why you want that to be in law?
When I look at it in terms of, first of all, you're having this prescribed form, and if you never put it in the first place, somebody can ask you for it, but it was not contained in your notice. I can understand for some unique situations, but from you saying the law that it may be there, then it gives the reason that I'm going to look for it. And I may not proceed where in the absence of you providing it. But I don't know. That's my...
Yes, members. Yes. Yes. Do we retain these provisions, members, or do we move to have it removed from the bill?
Chairman, I just have a difficulty. If you're giving a direction, why also give recommendation which you may ignore?
Yeah.
I would think that recommendations would find its way in the directions, which has to be obeyed, and then leave it there. I don't think we need to. If somebody, I agree with those who say if somebody asks you, do you have any idea as to how we could fix it, or you want to volunteer, saying, down at John's shop, this happened, you may want to consider that. But leave the recommendation out, because our job is not to, the job of the OSHA, ask people, is to get it fixed, not to tell them how to fix it.
Any further comment, Minister?
That's before you go to the ministry.
Yes.
I see where you may give notice and recommendations, but it's not an offense. But your direction, is that you may give direction also, or you shall? I'm not clear, but I don't see where, if you don't comply to the notice, I don't see you state anything here whether it's an offense or not.
CPC?
That's the problem I have with the use of the word direction, especially when in clause 177 2B we speak about measures, and in the compliance section we just say if you fail to comply with a notice. And that's why I'm saying it creates a bit of confusion when you use the word direction here. And I'm asking the question, is it everything in a notice? Are you saying then that there's certain things in a notice that may not be directions that you need to follow? So to remove all doubt, just speak to a notice, being able to refer to these things in 182A and B and take out the use of the term direction. And then 178 would apply because you're speaking of the measures in the notice.
Any further comment, Minister?
Mrs. Celia Brown, killing direction?
She's... All right, go ahead.
No, I'm just trying to get... Celia Brown.
Sorry.
Are you
Chair?
killing?
Sorry.
Are you killing the item direction?
Or she's giving us one.
Making a recommendation.
Yes.
Chair?
Yes, Mr. Basco.
Two things. The first was that Member Brown had asked if the Trinidad legislation dealt with inspections or investigations by police officers.
Yes.
It doesn't. They only appear when an inspector is exercising a power and thinks that he or she may need police assistance in carrying out the functions. The other thing was, I'm not sure I'm understanding if there's an issue being raised that it's not an offense to comply with a direction, because some of the substantive provisions that deal with notices insert the offense-creating provisions there and not in the general clause 182. So, for example, in clause 178(2), it's an offense to fail to comply with a direction or notice. So it's just to get some clarity about what the issue is.
Yes.
Notice is not, but is there really a difference? Really? So if you issue a direction, yeah, but that is specific in the legislation. You have to specify it here if that is the intent. Yes, yeah, which just makes it.
Mr. Chair.
Chairman, it's a simple.
Yes.
Oh, go ahead.
Mr. Simmons, yes.
I would just want to, well, this is for the drafter really, but they actually use, we've kind of read over them, but there's more than one formulation that was used throughout the notices. You do have directions concerning measures, you have directions on measures, you have just measures, and then now you come to recommendations or the content of the direction. So I think once she goes through all of those various formulations, she will decide on which one to use.
I would still need, yeah, I would still need the ministry to clarify for me whether or not you want to have the authority to issue directions separate and apart from notices, or what is the intent? Yes.
Yes, Sergeant.
And that is where I wanted to go, Chairman, because different regulatory bodies have different regimes. You can have a place for a direction which is different from a notice. It can work. There are other regimes where it does work. But again, it depends on the effect. What do you want it to do? I was mentioning to CPC, for instance, that BOJ, so the BOJA, the Bank of Jamaica Act and the Banking Services Act, they have these different codes of practices. You have directions that can be issued that have force of law. You also have notices that are issued, but they do different things and different. So it's a different form of enforcement that arises, but then it would have to be very clear when you would issue a notice as opposed to when you would issue a direction. What is the purpose of both? But they can work depending on what the ministry wants.
Ministry?
Well, I just want to also add 175 also speaks to direction or notice, and the direction will be a part of the notice. So we need to delete, then right, so we need to take out the R notice from those. In relation to the recommendations and the fact that it is not a requirement for it to be followed, then rather than to confuse, we would just move for it to be deleted.
So you're deleting 183?
183.
Yes.
And when you look at how it's done in 173.3,
yes,
it speaks of an oral direction that must be confirmed by a notice. And remember, we had already decided that we don't think that direct notices should be given orally. You see how it's written in 173.3?
Yes.
The direction may be given orally, but shall be confirmed by a written notice. Is it that before, when you were thinking of having the oral notice, that is what you were terming as a direction?
Yes.
And once it's issued, it becomes a notice, which makes it a little cumbersome.
Yes.
In my view.
So CPC you will sort that. Okay, very well. Yes, we have decided to. So, Ministry, am I to understand that the direction, as you have said, it will form part of the notice?
Yes.
Okay, fine. So there's no need to distinguish between a direction. Okay. So that is, so the drafters will start it out. I just need to.
And just to add, Ms. Seeley Brown, for 173.3, based on the seriousness and the imminence, that is why the oral was really put there. So we would want the person to act, not necessarily to wait on the written, but because we have established that it's a serious situation.
Okay, so we don't agree with oral notice, and in today's technology,
Yes.
there's no need for an oral notice.
Yes,
It's so easy to send something electronically. We have our Electronic Transactions Act that applies right across the board.
Yes.
So text message
Yes.
and email can be sent from the phone. You also have people that can walk around with even these devices that can even print. You have
Yes.
portable printers. There's so many devices that are around. It is easy to actually stand up right there in the place and issue the notice and have it sent. As attorneys at law, there's no way we could ever support an oral
Yes.
an
Yes.
oral
I think
notice.
the point was made earlier today. Yes. Yes. So, Ministry, there will be no difficulty. We understand that.
We have no difficulty.
Absolutely no difficulty.
No difficulty with that.
Yes. So we can now proceed freely. Shall we go to 184?
184, subclass 1. The reference to hush officer is to be changed to the authority. Subclass 2 is to be deleted, as this is unnecessary repeat of clause 172.
We agree to that, members? Yes. Good. 185.
We also recommended that
Yes, Sergeant.
184.1, I would delete the word minor because you don't want there to be a big argument about what is a minor change compared to what is not a minor change. You make changes for A, B, and C.
So we agree.
Unless now you have an issue with. And then if you don't want to make substantive changes, then you say so, but I don't know what you mean by minor. Okay.
So members, we agree to delete the word minor from 184, yes?
Yes, because it might be, yes, or affect the intention of the original notice without more. Yes, yes. I think that is what is meant. And
Yes,
you won't want to change the material
substance
of a notice without more.
So what is the recommendation?
Depends on the policy, Chair.
Well, yes. Well, it is clear, it is there on the face that minor changes can be made. Minor changes can be made. Yes.
Chairman?
Yes, Member Brown.
Sorry, Chair.
Yes, Member Long.
I mean, with respect to removing minor, if we remove minor, we're allowing the changes irrespective of how major or minor. So we don't want to allow a change that could cause a steer away from the intent of the actual. Exactly. So I think minor should remain. Or necessary.
I suggest that we just say that, and this is along the lines of the Law Revision Act. So in Law Revision, they're allowed to make minor changes once they do not affect the meaning of the provision. So again, it's just a matter of saying once the substance of the notice is not altered, you can make, and they say correct grammatical or typographical errors.
Suggesting to insert.
Insert, yes.
Insert that.
Perhaps in B, they could put correct grammatical errors or references. Grammatical, the B.
Just a B, but the A is important.
For clarification.
Because I don't know what, you said to me, I'm in breach of section XYZ.
Yes.
And then you come and clarify 2-3 days after. That can't work.
So where are we now, members?
Sorry.
Yes, Mr.
Just throw it out for you to consider. Suppose you didn't have the correct name of the PCBU. Couldn't you make changes for clarification there?
The spelling, yes, good.
And again, we can again lean to the Law Revision Act. You can make such formal alterations as the names, offices, titles, ranks. So I think we could use something like that. So it makes it clear. I think it's better you spell things like that out. The kind of changes you can actually make to the notice. So if it is just in terms of formal names, if you got the name wrong, if you got the address wrong, although, sometimes people will argue about an address. Because the problem with an address is service. And service can trigger a number of things. Time starts to run when you have been served. And so we have to be careful about that. I would have thought just maybe about names, proper names being used, things like correct references, either grammatical or typographical errors. So either you referred to, and even that we have to be careful of. So if you put in a notice that the person was committing a breach under section 89, but you were dyslexic and you meant 98, that could create a problem. Because when you are served that notice, you're looking at section 89 of the law and trying to fix something that you think maybe relates to Section 89. You're looking at the wrong section. So I think we have to be careful. Can you give us some time to just look at this, though?
Very
And
well.
maybe we can lean to
I-
other precedents as well.
Certainly, I do not foresee a difficulty with that, members. Yes, so we're going to defer 184. 184, yes. And we will proceed. And we had agree with the deletion of 1842. So we move to 185, Mr. Mohan.
The ministry is recommended that we delete clause 185. Yes.
Yes. Okay, very well. All right, the lawyers are talking. Yes?
Is it that you wanted to delete it or you just wanted to change the reference? Meaning whoever issues, you want to also say whoever issued the notice can vary or cancel the notice? I mean, the Interpretation Act has it, but
Yes.
OPC is correct. Where we relying on the Interpretation Act. And then when we
Yes.
get to another place, I would say, oh, it's somewhere else, and then other person.
Ministry, you have heard the recommendation.
Yeah, well, the recommendation is from OCPC that we should have it here. Is that
Yes,
the
and with the
understanding?
modification, a notice issued by the authority may only be varied or cancelled by the authority. Is that what you're proposing?
Yes. So we have no objection if it references the authority.
Yes. So members, we agree to that?
But
For the verse.
let me ask family on the mic. Will, for the sake of the employer, for example, or the person getting such notice, would it be spelled out in the regulation or wherever as to what are the means by which you can cancel that notice?
AGC, we have a comment in this regard. Since the notice has to be in writing, I don't know.
You issue a notice.
Yes.
You issue a notice in the first instance for a particular reason.
Well, yeah, the workers, yeah.
So,
The workers would want to know rather. Not there.
that's why I'm asking.
There must be a reason why you issue notice. in the
You
first
issue the
place.
notice for a reason. Why cancel it? You now have a situation, Chair, where you can either make minor changes,
Or then cancel.
variation, or cancellation of the notice. Yes. But
okay.
from my own simple mind, I was just trying to ascertain what would have triggered a cancellation of a notice.
Well, how would you, because you remember, Chair, once you, in that notice, you're going to have the time to comply. Once you've complied, you've complied.
No. Why should the notice still persist?
But it's not persistent. But
It has a time. Suppose it has a time. Suppose it's 4 weeks.
Yes, so
And
by
you-
the
and you
time
comply
you
within
get,
2 weeks,
suppose
that's what
you-
you're saying?
Suppose you observe a contravention, and by the time you get around to serving the notice, they have remedied the
okay,
situation.
I see what you're saying.
You didn't serve. So, Chair, you can't cancel what you didn't serve.
Well, what
You
what
prepared
makes-
it. You prepared it, but you didn't serve it, so you can't cancel it.
The issue.
But it's not
No,
cancelled.
no, Chair. If you are going to submit a notice, it must mean that there would have been you would have identified a contravention, right? And so the record would have already been there, and so you must be cancelling. What are you cancelling? Even if they fix it, you would want to have the record of a notice.
Can we then say in the legislation then that the notice shall cease to have effect once the party complies with the notice? Something to that effect?
That's not
No?
different thing.
No, somebody else has to verify the party, as I can't be just saying I complied.
The CFO officer would have to go and examine.
The authority, yes.
So can't you then?
But
You see this cancellation of a notice? I don't want it to lead to someone's being unscrupulous by saying there are reasons. Cancel this thing for me now.
So
to support.
Don't expose the authority to anyone claiming that.
Would it help then if you add words to the effect that the authority must certify that the compliance has taken place, and after that the notice was...
If you identify that there is a breach and you would have reduced that breach to writing by a prescribed notice, there must be something for you to clear that the breach has been fixed, rather than just leave it to somebody deciding on their own that I'm going to cancel it.
No, cancel can't be the right word.
Cancel is the word here.
Yeah, because, Chair,
okay.
As I listen, because we have to be careful. As I listen, if we are giving impression is after you have done the remedial work. So after the remedial work is done, you're not cancelling. You have issued the thing. And you have done what you're required to do. So it's a compliance certificate or something you need to issue to say that this establishment has adhered to. But to leave that the authority can cancel, I am afraid of that phone call from the big establishments. And you laugh, Chief, but you know the reality.
Yes. I will hear Mr.
Hear me first, Chair.
Robert Breaker, but I will hear you see.
What back you going to speak to it? AGC has a suggestion, Chair.
Yes. Yes.
So we were looking at what the scheme is in the CARICOM model bill. And we don't mean to further complicate the bill by speaking of another notice. But Section 65 of that legislation speaks to a notice of compliance. And what it is a bifurcated approach. So where you do have the notice that is issued, say from the inspector, once you've complied, you send a notice, and that really triggers the ASH inspector. But it also, an inspector can also, of his or her own volition, go back to see if you have complied. And you don't need to do a compliance notice if that obtains.
Very well. Mr. Robert Baker.
It's Richard, actually.
Richard, sorry.
Yes, sir. I think we are missing an important point here, where you speak about the serving of a notice. So if that notice wasn't actually delivered, it was not served. Now, that is different from the remedying of the breach. So you would still record the breach that was there and the fact, after verification, that the breach had been rectified. But the notice would never have been served.
No. Yes. So, I am the person conducting business. And if there is a breach, it is the notice that is going to indicate to me that I'm operating in breach by the authority. You disagree? Tell me why you disagree with me. I will agree with you if you come with a good reason, you know.
An inspection.
Yeah.
An inspection is carried out. There would be dialogue with the representative of the entity during that inspection. The breach is identified, would be communicated. It is a decision you are taking if you are relying on the serving of a notice. You ought not to be serving a notice if the entity agrees to remedy the situation within. It can be remedied within an hour.
The oral notice then?
No, but it is having the inspection done with the representative, and the breach that is there can be rectified, say, immediately. Now, If the notice is being served on the spot, then that's fine because it would have been served. Now, if it is a situation where you have to go back to the office to prepare that notice for it to be served, when you get there to serve it, the breach is no longer there. The notice is an instruction to remedy a breach, which it would not have been there when you get back there. So but the breach would have been remedied.
It from you that you are an authority at the Ministry of Health that might have approached it that way. Now I want to be sure that that was the way that the Ministry of Labor, in putting forward this area in the legislation, if that was your thinking. But then again, you look so blank at me a while ago.
Chairman, it's obvious that the intention is compliance.
Yes.
And if compliance takes place, then a certification or something,
Of
or
compliance.
notification of compliance is
Is
done.
enough.
What I am concerned about, and what I think my colleagues are concerned about, is in the common parlance, putting butter up post mouth. When somebody, all things being equal, is cool. But we don't live in a world, not just a country, in a world that is equal. I see attorney generals or district attorney being terminated in southern New York, right? I see that. So I know I live in a world where things happen, be it at the base of some president, some minister, some wealthy businessman, some powerful union leader, and I don't want that. So if you go to cancellation and to give a power to cancel, when really what you want to say is that the notice will be of no effect because you have complied with it, then the word cancellation should go, and we shouldn't entertain it, because as I say, that word oftentimes is butter a puss mouth, and there are too many pusses in the country.
Member Gill.
Chairman, I beg you, crave me indulgence. Earlier this morning, we spoke about a progressive way of treating with these things, rather than lead to imposing sanctions or going to court. Now, let's say for argument's sake, we go with what Mr. Richard Baker was suggesting, that an inspection was done and you give time to remedy. But there would have been no record of the breach. And so you may commit another breach and want to escape the progressive approach. The notice is to a specific breach that would have placed on record that an establishment had conducted a breach. So it still would have to be served. Even if you come and inspect it, you know. That's my thinking. That's my thinking.
Yes, Mr. Baker. Richard.
There are many times when a breach is there. Some of these breaches can be remedied even before the officer leaves the premises. It will be recorded as a breach that was found, and it will also be recorded as having been remedied. A notice is served, either the proprietor refuses to, or it will take much more time for it to be done. So again here the risk comes into play. If it is at the level of risk where the notice is to be served and it can't be remedied before you leave the premises, yes, you take action to serve that notice. the breach would be there, and no matter how severe the breach is, if it is rectified immediately, there will be no need to serve a notice, because the notice is really an instruction for you to, within a certain time, remedy that breach. And if it is remedied before you leave there, then there's no need for a notice to be served. But you would still record that the breach had been present and also that it has been remedied.
What you're distilling there, sir, is a variation in terms of the notice for improvement and what triggers this type of notice for improvement as opposed to another one.
Chairman.
Yes, I remember.
Just coming back again to my mild, moderate, and severe treatment of the breaches that would be risk-based. And what I'm kind of hearing is somewhat an approach where if the breach is such where it is a quote-unquote mild breach in terms of the risk to the persons or whatever. So, okay, let's say it's a gas leak. That is high risk in terms of if it continues, but can be quickly remedied. The fact is that it is still a breach. So there has to be that level of that recording of the breach. But if it is a situation where it cannot be easily remedied, the leak cannot be quickly fixed, they have to bring in persons' expertise, it then escalates to another tier of risk, and then now would require another level of quote-unquote notification and recommendation. So you're gone back to recognizing it's a different approach that kind of has to take into recognition the level of risk posed, and almost a treatment of how you remedied that situation. But you cannot have it where it is just cancelled.
Mr. Chair, question here.
Yes.
The authority goes in, so the usher officer goes in on behalf of the authority with the prescribed form. Can you sign on spot and give that notice on spot?
Yes, that can be done.
Right. You can be done. So, Mr. Chair, we have to take this to a higher standard. So whether it take an hour, 2 hours, or 2 days to remedy the problem we have in there. If the usher officer goes in and the problem is at the level that you think that prohibition notice must be given, you give it. If the employer can take an hour to fix the problem, fix it. And then if you, after fixing it, if you have the compliance notice and you want to go have lunch and come back, you're given the compliance certificate. That's the standard we want to set. So the time to repair the breach is immaterial. And therefore you have your records, and it's done in a formal way, and it's not just to write it down in a logbook, but you have the record that you issue. And I think if you develop that standard, parties will understand. So if the authority, if the usher officer on behalf of the authority can issue on spot, then the time frame is immaterial.
So let me get this. So it doesn't matter then if the problem was already remedied, you still give the notice? Is that what you're saying? Irrespective of if it happened an hour ago and it was sorted out within that time frame, do you still give that notice or no?
Up at 11 o'clock and have the dialogue with the employer or the person conducting the business. Then before you start to work, then I give you my notice. If you can do it in an hour, amen, so let it be. And if I can go have lunch and come back, I go to our next place and come back, and you have repaired the wooden floor within an hour, then I give you a certificate of compliance. And we're all happy and go merry way for safety and health. Right, so the point I'm saying, it might take a week, 2 weeks, but it's up to the usher officer who has a technical skill set to determine. But I think the notice must still be served.
All right. And I've heard you, Member Skeffrey. But what happens in circumstances where the notice has been prepared, but there is no longer a need to serve the notice.
How would you get the situation? I go.
Let me
Why
tell
would the
you.
need suddenly disappear?
Because let's say there is an issue between the preparation and service, and by the time you get around to service, the contravention has been remedied.
But the contravention did exist.
But it
so
no
you
longer
can
exists.
immediately then issue the certificate to resume work or resume business. But the fact is that it should be recorded that there was a breach.
Mr. Chair.
It should be recorded, even if the issue no longer exists. The fact is that because what you can set yourself up for is that you might have repeat offenders who just slip through the cracks because of that.
Mr. Chair, the notice must like be a ticketing system, you know. Where you walk with. So it can't be anything too technical to be prepared in an office for 2 weeks. Like you give me a traffic ticket. So you walk with it.
Okay.
That's why it's a prescribed form.
I want to hear from the ministry. Yes, and then we will have to take a position. Ministry?
I just want to bring you to, let me start by bringing you to 180. Clause 180 says that a notice means an improvement notice, a prohibition notice, or a non-disturbance notice. Now, if you look at 185, in terms of the discussions around cancellation, if a notice, for example, a non-disturbance notice was issued, and the notice specified a period of, say, for argument's sake, 7 days, and the authority would have concluded its investigation on the site and would need to release the site. I mean, in those circumstances, it was considered that we could cancel that non-disturbance or withdraw, you know, so, because
situation you would have given clearance. You give a non-disturbance, so you would have given clearance. But this thing about cancellation, it's wide. Somebody can just get up tomorrow morning and decide and say, hey, me have cancelled
What are the
this.
grounds for cancellation?
What's the grounds for the cancellation?
well, if you look at 187, subclause 2, some of the issues that were being highlighted, the regulations may prescribe the manner of issuing of notices, right? We were of the view that we would have had to go some more detail in terms of these, because this section is dealing with the general requirements applying to notices, and we have 3 notices here. So some of the concerns that have been raised as to how we should approach the issuing of notice, we would be addressing those in regulations. In terms of the language, as member Gail was speaking to, whether it's varied or we use cancelled instead of revoke, that is something that we can look and have discussions with the drafter as to the best way to represent it. But this was trying to deal with generally the notices. So we were speaking about breaches and cancellation. Yes, the regulations would now set out the manner of how, for these notices where breaches are concerned, how they will be addressed.
Mr. Simmons, I will hear you, then the drafters, and then we.
Yes, I was just wondering if there's a possibility that a notice could have been prepared substantially incorrectly.
Yeah, it's an invalid notice.
I use the word substantial because we have minor there. A practical example could be if you go to a workplace. You go to a workplace and there are actually 2 PCBUs working there. For example, one entity owns the building, and so on the building you see the name of that entity. But one floor of the building is actually has the entity that you actually inspected. So instead of putting the name of the entity that you actually inspected, you just put whatever you see on the building. That would be a material defect in the notice. Why couldn't you cancel it in that situation?
Yes. Mrs. Celia Brown, we'll hear from you.
I'm
absolutely
officially
no need.
confused because I didn't think that when you spoke to cancellation, that is how it was supposed to be interpreted, especially in light of the fact that we have already provided for changes to a notice in clause 184. So I can't see that as a reason for cancelling
Okay.
a notice. I don't know.
All right. Yes.
Can I just say, Chair, what we agreed to when Mr. Bashko, the proposal put forward by AGC.
No, that warrants an apology.
In relation to the compliance notice. In relation to compliance notice, I have no issues with that, Chair.
Yes.
And Mrs. Aldred just drew my attention to a recent act that was passed, the building code, and how they've set it out. So I would use that once that is agreed to as my basis
So
for redrafting.
are you proposing then that we delete as put forward by the ministry originally, and we now move to a scheme where the compliance notices are issued? All right. Ministry, you have any comment on that?
Well, we are in agreement with what Mr. Basco had said about the notice of compliance, because notices are a serious thing, and if we can issue something to show that there has been, as it relates to the suggestion about moving towards removing it totally, just want to get a better understanding from CPC as to, because this is general, dealing with more than one notices, would we need to split it out for these notices, or should we just have it as general for all?
Any comment, Mrs. Celia Brown, on retaining the provision as a general provision? 185, and notwithstanding, we'll still introduce the compliance. Okay.
To have to now set out provisions to how we're going to vary or cancel. Because this without more doesn't help us. Especially as I said to you, when we use variation in legislation,
Yes.
we specify how you may vary a notice or an order. So if we're going to do that, which I don't think we need to do, here we're going to have to specify what is meant when we are speaking to variation or cancellation.
So you encourage deletion?
Yes,
Okay.
and yes.
Members?
I'm very clear the cancellation thing won't get my support.
Okay. All right, members. So we delete clause 185, and we will seek to introduce a scheme whereby compliance notices are issued. So that is the position. Mr.
Yeah,
Simmons.
I just want to be clarified, what's the position regarding that section? I mean, I heard a compliance period, but I think
185, the members have agreed to delete it.
but Mr. Celia Brown also mentioned something about a cancellation. Just want to know, is that being
Oh, no.
It can substitute for a compliance notice.
okay? So that would also work for where the notice is bad from the very beginning?
Yes. Let me hear Mrs. Celia Brown.
Isn't that a different issue? You remember you speaking about, I think are you referring to the issue that was raised in clause 184, where Mrs. Aldred was speaking to us using words similar to the law reform revision?
Clause 184 was dealing with where you're not changing the notice substantially or materially. I'm asking, what about the situation where the notice is materially bad from the very beginning?
Oh, that's something else. Yeah, well.
If it's what? Just say that again.
It's bad, it's invalid.
Issue a new notice.
Okay.
Rather than somebody will carry it to court. Right?
Yeah.
Okay.
Chairman,
Yes, Mrs. Celia Brown.
Chairman.
Yes.
Yes, that'd be maybe a little bit of devil's advocate, but really thinking about what you mentioned regarding cancellation and possible circumstances, because we also don't want to create a situation where a business owner is somewhat penalized in whatever repercussions that could happen for something that was somewhat innocent. So let's say you have some sort of industry where you have vents, fans or something like that that needs to be on, and a certain amount of them for safe ventilation, etc., etc. And there is a deficit in the amount of ventilation, but there is when the officer sees this situation, is not aware that there may be a schedule for these things to come on, and issues a notification based on that. But really and truly, subsequent investigation recognizes that it probably wasn't the timing for when those mechanisms were supposed to be in place, etc., etc. The business owner, the owner would now have something on his record that could affect him. That could affect him later on. I don't know. I'm just saying that, you know, to say, because it is a lot of power, and you could have, you know, you have ILO, this, that, all sorts of compliance things. You never know how a permanent decision like that could affect a business. So I just say, you know, I don't know how absolute I am, because it may lead to unforeseen consequences.
Colleague, through your chair.
Yes.
In such a situation, the OSH officer would be negligent if he didn't discuss beforehand with the employer, the person providing the service, and hear from him or her that this is the thing. And then an improvement notice may be the one you want to put in there at that point.
But that's what I'm saying. In that case, wouldn't it be cancelled? Would not be grounds for it to be cancelled?
No, you don't need to. Put it another way. Once you bring them on site and do the work, you have complied. Don't need to cancel, because you're going to get something, say, yesterday I served you.
In my scenario, there's no work to be done. That's the point.
No, but then you can't, if there's nothing to be done, you can't then issue a notice. Right? If you issue in error, the answer to it is to issue a compliance after.
But it would be on the record that there was a thing.
Put this way, that record is not going to stop the bank from lending them money. Yes. Or the workers working with them.
That's exactly what I was hoping, and I just don't want a situation where we're creating a bottleneck for business owners.
No, certainly not.
Okay.
Certainly not. Ministry may proceed. 186.
Clause 186. To be deleted based on advice received from the AGC before the Joint Select Committee in relation to similar provisions contained in Clause 98.
We agree, members? Yes. Ministry 187.
187 is to be deleted. The general provisions are to be included in the bill relating to the service of notice.
Yes. And one.
In that chair, just to be clear, that the way it is formulated, that 187.1a not be the way it is formulated in the general notice. Because I don't think we can send an email to the last known place of address our business.
Yeah. No, it's standard language for bills, man. Yes. Yes. Yeah. Yes, Mrs. Seeley.
It's not a complete deletion of 187.
Yes.
You just want it placed probably earlier up in the part where we deal with it and reformulated.
Reformulated and repositioned.
Yeah, because what he said was deleted. Yeah.
It's a reformulation of 187. We agree to that, members? 186, Mr. Basco, I see you have, no, I'm going back because I know that AGC had made a comment.
The comment here?
Yes.
Given the discussions on 185 and 184, we think it's best to just delete clause 186 to avoid that
fine,
issue.
which is what we have certainly agreed to. So we move to 188, Minister.
Clause 188 is to be deleted. Well, remember we had some session before when we were discussing about notices and it being burdensome to have notices being displayed. Member Brown you remember we had that discussion.
I mark up this morning again. I just thought since the home could be a workplace, and Kavan, we want to state that the committee treats the home as a workplace, because there may be some misunderstanding which my colleague I think will speak to later. So I'm looking at my house, and I asked my son, if we put a notice 2 doors down from my house, is that near my house, which is the workplace? And his answer, it is relative. So, are 2 doors down. So, in other words, it needs to be clearer. What is it we want?
Okay, fine.
Yeah, that's just clearly the language. And then when you get to 188,
so your concern is the use of the words "are near the workplace."
Yeah, it needs to be more precise.
Standard draft that we use, being in a conspicuous place, so we will just use that.
So you will
redraft it. Yes.
Redraft clause 1881. So that is the ministry. I've heard what CPC is proposing, that 1881 be redrafted. Any comments?
We will be guided by them.
Very well.
No problem with that.
Just one question.
Yes,
Why are we keeping that section?
Yes. AGC, you want to respond to that?
It's about 188 display of the notice?
Yes.
Yeah, why are we keeping it?
Because it's a normal provision to keep when you issue notices and there is non-compliance. Usually a notice is supposed to be prominently displayed in a conspicuous place to alert not just employees but other persons who are coming to the business. So this is a normal thing. It's in most other, like I know it's in like environmental laws. I can try and find it in town and country planning. It's in a number of them where you give notice to persons who are going to come onto the property as well. And then, of course, when there is compliance, it is removed.
But why would legal ask that question? That's from my knowledge.
I was just curious as to who it is that you want to see it.
To see, yeah. Royal at large.
I can think about it more, but I'll think more about it.
All right. So, another issue with 188?
188, 3 and 4. 188, 3, a person shall not intentionally remove, destroy, damage, or deface a notice displayed under subsection 1 while the notice is in force. And then, so the intentional there, we're insisting that there has to be some mens rea. Yeah, there has to be some mens rea. And
you destroy my notice.
Yeah, but I could have backed up with the car and it damaged it. So, is this what we intend, that we must prove that any damage was intentional?
Let me hear from you, Mrs. Seeley Brown. Use the mic.
There is about without reasonable excuse, Chair. When you create those sort of defenses, it's sometimes difficult when you're prosecuting too.
So that menstrual element, are you saying that we should remove it? Yes. Any comment from AGC? Or, yes. So AGC will, CPC will advise us. Yes.
So we're not deleting
No, we're not deleting. Just yes. Because one can see why the provision is
It could be
included.
that the person should act. It could be that the person should act to prevent the destruction, damage, or deface the notice.
Act to prevent.
To prevent it from being destroyed. That way
That-
you're making.
that
That way you're
sounds
making
burdensome.
sure. 881.
Yes.
Sorry, this is a notice. This is a notice that you get from the authority. Yes. And so, what's the size of this notice for it to be placed prominently? Is a scroll where you roll out, or written on a cartridge paper?
Yes, we did say earlier. Laminates. So, can you move on now, Mr. Mahan, to remedial action?
For remedial action, clauses 189 to 191, the ministry is recommending that these clauses are to be deleted. From a practical standpoint, it will be difficult to implement the requirements as set out in these clauses. The cost, the liability, the administrative monitoring that may be required may place such a burden on the authority and the obligations to, and it can be misused because persons can just leave things and expect the authority to come and
create
clean up.
an exposure for the authority.
Yes.
All right.
Chairman, I'm disappointed. This was an opportunity to employ a lot of the young lawyers coming out of now and Manly. And so we could have been creating jobs here. And we could flood the courthouse with these cases. But good sense have prevailed. And so my disappointment is tempered.
Yes.
Plus, of
So
course,
we agree to the
of course I was envisaging all the government lawyers going over there to fill it.
So we are deleting 189 to 199 to 191. We agree. Deleting clauses 189 to 191. Well, I'm just going based on the ministry's document. We're going to deal with 192 and 193 next. So we'll take it in parts. And 191. 89, 90, and 91. So we're going to be dealing with 92 and 93. No? 192, 193.
So for clauses 192 to 193, which speaks to injunction, the injunction would have to be sought by the authority. The AGC has some comments they were not in agreement with the retention of these clauses. So I'll give them an opportunity to speak on it.
Provision should be deleted, Chairman.
Very well. Well, they have indicated on their their response that we have.
Sorry, so let me just explain. You don't use injunctions in this kind of scheme. You have a notice. You are supposed to have compliance with the notice. There's a criminal sanction if you don't comply. That's your scheme. Injunction thing is a civil remedy. It doesn't form a part of this because you have your enforcement is a criminal sanction that if the person doesn't comply with the notice, you carry them to court and you fine them, and you should have an appropriate remedy for that. But remember you have always been saying the whole point of this law first is compliance. So this is why we have been suggesting even maybe a tiered approach. But when you get to that point when you're not getting compliance, it's a criminal sanction. It's a criminal sanction. Because what do you do with an injunction? Remember, it's a civil remedy. What do you do with an injunction?
Yes, Mrs. Michael, you wish to make a comment? Yes.
Chair and members, we were thinking that as it relates to the criminal sanction, that when it goes to the parish court, and the court, what the court will be imposing is a penalty under the schedule. That does not of itself, to our mind, means that the breach is remedied, because all that will be happening there is the fine being imposed, but it does not necessarily mean that the defect is addressed.
Right.
So what
the court can order it. At the same time that you go to court to ask for the fine, you also ask the court to issue an order, not an injunction. An injunction is saying something must stop, something must not be done. What you want is at the same time, no, the injunction it works in a different way. So what you do is, which you do in other laws, you would ask the court not just for the fine to be imposed, but also for an order that would now leave them liable to all sort of court sanction if they don't comply with the court order, to ensure that there is compliance with whatever they're supposed to do. But it's not, that wouldn't be an injunction.
Do we need to insert in the bill that you not only the fine, but whatever order the court may think fit? So we should insert it in.
Yes. Such order as it deems necessary. So where would that fit in this bill, or we want to agree on that now? For the insertion of that clause to say that the court may make such order as it deems necessary. Okay, very well. Very well. So we are going to, Ministry, any further comments based on the advice from AGC? So we will delete clauses 192 and 193, and we agree to the insertion of a clause in the bill to say that the court may make such order as it deems necessary. So that takes us to the end of part 10. We have part 11, but having regards to the time, and I know that Member Gale has indicated that he wishes to raise a point under any other business, so we will move from item 5, and we now go to item 6, which is any other business. Member Gale?
Chair, maybe, these proceedings are being watched by the public in various means. And coming out of last week's discussions around the expansion of the workplace to include household, I believe the Householders Association may have misinterpreted our approach based on the gravity of the discussion, because there is this view that the committee is not in favor of extending the workplace to include dwelling house. And one of the things I would want to suggest based on, and this has come to me in an informal way, but that's why it's important in the first instance where, certain groupings or associations come and make their submissions in the first case. And it's always important coming out of this for the education plan to create that level of confidence that the objective of this legislation is to protect all workers, barring none. And so I want to, maybe we can invite that association or whatever grouping that might complement support for the association for us to be able to clarify what may have been misinterpreted based on the candor of the discussions that we would have had. There is no intent on the part of this committee and all the representatives here, including the technical teams, not to protect any worker. The concern was raised in terms of how we treat the dwelling house as part of a workplace and whether or not we extend some of those factors in treating with that aspect of it being a workplace. So I just want to reinforce the point that there's no intention prescribed in any way, shape, or form to exempt household workers. In fact, Mrs. Bennett Campbell was quite clear in her representation to say, coming out of the support of the ILO convention, it is required as part of this legislation to extend protection. And so I believe it's important to clear up what may have been any misunderstanding on the part of anyone in the public space.
Chairman, I want to add to Senator Gill's comment.
Yes.
Because the point was made here that our jurisdiction, Jamaica, may be the only place where domestic helpers are being included. And the other legislations didn't capture that. And so I too have been taken aback by that. So much so that I want to commend the effort, however, of the Domestic Workers Association for the good work that they have been doing. I want to recognize the fact that your ministry on Thursday sent out a video acknowledging and supporting International Domestic Workers Day. So it's not the position of the ministry nor us in this committee to exclude. We want to include them. The issue that arose was to what extent you could get a report against an employer and what was the best way to deal with that whilst protecting the domestic helper. I think I used the word woe be unto that helper who is seen to have reported. And we even suggested that maybe the public health would be a route to take to protect that domestic helper from victimization. So I'm surprised that it is, and maybe, Chair, we could invite them here to represent all the Domestic Workers Association here, so that they may raise their concern and we may clarify, hopefully to their satisfaction, that they are to be included in this. And so I don't think it's the O, because we agree that they are going to be protected. Right? So we just need to do that so that, again, we need all in the society, and it's thousands of them at the margins, underpaid, overworked, but we need their support to make this work. And we want to assure them that we are with them, We understand them, we hear them, but we don't think they interpreted what was said correctly. May it please you, sir.
Thank you, members, for highlighting that misunderstanding which may exist, particularly in respect of the Domestic Workers Association. Certainly, I agree with you, members Gill and Brown, that we should have them here, to clarify any misunderstanding. The point was being made by the ministry that by virtue of the ratification of ILO Convention C-189, the domestic workers are properly covered by this legislation. And I will ensure that the letters is sent out to that umbrella group, inviting members to participate in these discussions, so that they, having left here, would be in a position to educate other members that this legislation is very far-reaching, and so too their rights will be protected under this new bill that we hope to have in law not too long from now.
Just to say, sir, in the communication to them, just to ensure that we remove that freedom of fear.
Yes.
We might seek to invite them, but we can't compel them. But whatever we communicate to them would seek to dispel that notion that they are not being protected. Yes,
and the communication will do just that. So hopefully during the course of this week, the letter will be dispatched. I think what we need to be clear about is that whether or not there is one group involving domestic workers, or there are several groups out there. I don't know if you have any information.
I'm sorry, sir, I don't have that information.
Yes, that would be good. But we will get some information, and if there are more than one groups, then certainly we will invite all groups. But yes, we do. The information is not verified, so we will proceed to have them here. There be no other business.
Before you get to that,
Yes.
Chairman, we know that there's a replacement for the Honorable Shiny Robinson as
Yes.
portfolio minister, and it's not for us to ask whether or not there'll be changes to the committee composition, but we probably will anticipate that, because since my friends have told me that at least one member of this committee has now gone into a position where he will no longer serve on the committee, and the barbs from that side about high-priced lawyers will stop.
As it will cease.
So, but we'd also like to congratulate our colleague
Yes,
on his elevation.
Certainly, we congratulate Member Campbell. No, don't worry about that. Yes. But if there are any changes, member, certainly we will be duly notified. If and when those changes come. So we may take the date for the next meeting, which we have.
I just raise it because sometimes the officials act and miss these things, and tomorrow may be an appropriate point.
Yes.
Since we're meeting next Monday,
Yes.
and there'll be no other opportunity. It's about changing.
Yes, Member Brown, we will duly communicate any changes. We have set for next week, Monday, the 29th. I already am hearing AGC and CPC saying we sit for half day next week. Yes, so we No, well, the truth is that we could do Monday and Thursday, since we're going to do half day
I think
next week.
Sexual harassment. I will check. There may be, if,
Hold on, let me just see.
if there's a virtual meeting.
All right, so you see, it was easy to come back at the whole day. All right. Yes, man, I think so. Sexual business. So we will be sitting from all day next week, Monday, 10 to 4. So, so we now have the adjournment. Yes. Yes. So the meeting is now adjourned until 10 a.m. on the 29th of June.